Be seated. All right, I understand we have a verdict. I know we have lots of folks that are interested in the outcome of this case here. I've also heard at least 6 Amber Alerts while I was in the back buzzing in here. So if that happens, I'll just ignore it and pretend I didn't hear it. I want everyone to just understand that the jury's been working diligently on this case for the last 4 weeks of trial and for the last several days of deliberation. I don't want any outbursts one way or the other. If you don't think you'll be able to restrain yourself one way or the other, then you need to step out. All right, anything else we need to take up before we bring the jurors in? All right, we have our 2 alternates, all right? All right, go ahead and bring them. Well, we have 4, but only two are coming. All right, I understand y'all reached a verdict.
Yes, Your Honor.
And is it signed by you as foreman?
Yes, Your Honor.
All right, if you'll hand it to the bailiff, then I'll review it, and then I'll hand it back to you. All right. If you'll hand that back to the foreman. All right, sir, as foreman, I'm going to have you stand and publish your verdict. You can do that just by saying, "We, the jury," and then to each count, say, "We find the defendant guilty or not guilty," as to each count.
All right. We, the jury, as to the count 5, we find the defendant guilty. We, the jury, as to count 4, find the defendant guilty. We, the jury, as to count 3, we find the defendant guilty. We, the jury, as to count 2, find the defendant guilty. And we, the jury, as to count 1, find the defendant guilty.
All right, we'll hand it back to the bailiff. Madam Bailiff, you can show it to counsel. All right, anything y'all want to take up?
No. Oh, we would ask you to poll it.
All right. All right, ladies and gentlemen, the Defense has asked that you be polled. I'm going to ask you a series of questions. We're going to run through each one of you. If you still remember your original jury number, if you don't, we'll give you some prompting. But if you'll stand up, we will then, I'll ask you a series of questions, and then I'll move to the next juror. After you see me do it twice, you'll understand what we're doing. All right? So, Mr. Bailiff, Mr. Clerk, if you'll call the juror.
Number 3.
All right, ma'am. Is that your verdict?
Yes, sir.
Was that your verdict in the jury room?
Yes, sir.
Was the verdict agreed to by you?
Yes, sir.
And is it still your verdict?
Yes, sir.
All right, you can be seated.
Number 7.
All right, sir, was that your verdict in the jury room?
Yes, Your Honor.
Was the verdict agreed to by you?
Yes, Your Honor.
And is it still your verdict?
Yes, Your Honor.
All right, next.
Number 14.
All right, ma'am, was that your verdict in the jury room?
Yes, it was.
Was the verdict agreed to by you?
Yes.
And is it still your verdict?
Yes.
All right, you may be seated.
Number 28.
All right, sir, was that your verdict in the jury room?
Yes.
Was the verdict agreed to by you?
Yes.
And is it still your verdict?
Yes.
Number 40.
That's me. All right. Sir, was that your verdict in the jury room?
Yes, Your Honor.
Was the verdict agreed to by you?
Yes, Your Honor.
And is that still your verdict?
Yes, Your Honor.
Number 41.
Ma'am, was that your verdict in the jury room?
Yes.
Was the verdict agreed to by you?
Yes.
And is it still your verdict?
Yes.
All right, next.
Number 48.
All right, ma'am, was that your verdict in the jury room?
Yes, Your Honor.
Was the verdict agreed to by you?
Yes, Your Honor.
And is it still your verdict?
Yes, Your Honor.
All right, you can be seated.
Number 50.
All right, ma'am, was that your verdict in the jury room?
Yes, sir.
Was the verdict agreed to by you?
Yes, sir.
And is it still your verdict?
Yes, sir.
All right, next.
Number 60.
All right, sir, was that your verdict in the jury room?
Yes, Your Honor.
Was the verdict agreed to by you?
Yes, Your Honor.
And is it still your verdict?
Yes, Your Honor.
All right, you can be seated.
Number 65.
All right, sir, was that your verdict in the jury room?
Yes, Your Honor.
Is the verdict agreed to by you?
Yes, Your Honor.
And is it still your verdict?
Yes, Your Honor.
All right, you can be seated.
Number 71.
All right, sir, was that your verdict in the jury room?
Yes, sir.
Was the verdict agreed to by you?
Yes, sir.
And is that still your verdict?
Yes, sir. Number 79.
All right, sir, was that your verdict in the jury room?
Yes.
Was the verdict agreed to by you?
Yes,
And is it still your verdict?
it is.
All right, you may be seated. That's all of our jurors. All right, anything else?
That's all, Judge.
All right. All right, ladies and gentlemen, that ends your service in this case. I want to thank you for your service. You are now free to go about your day and your lives and look up anything you want to about the case, talk to anyone about the case, or not, as you choose. That is completely up to you and how you want to handle that. There are the media folks have reached out and want to talk to you. The way we're going to do that is I have some packets of information from them that I'm going to give you in just a moment. Before y'all leave the area, you are free to stay and talk to anyone you want to. You are also free to leave and not talk to anyone. There are many folks that would like to have an opportunity to talk to you. Again, that is completely up to you. And whether you want to talk to the lawyers, any of the family members, or the media is completely up to you. And they will make themselves available. I'm sure the media folks will be out the front door. If you want to talk to them, I'm going to direct them not to bother you if you want to go out the back door and go to your car and leave the premises. All right, so with that, y'all can be excused to the jury room. Yeah, and if the alternates, y'all can step out. I'm going to give y'all that same information. So if y'all step out with the bailiffs, y'all can come through. They're going to want you to walk around. All right, y'all want to schedule sentencing?
Judge, let's go ahead and schedule it for sooner rather than later.
All right.
Due to the
Well,
bill.
let them step out. we can shoot for the first week of December, second week of December. I'll talk with Tracy. I have jury trials scheduled the week before Thanksgiving. We might can do, I know I have a conference the first full week of December, so second week. So we will reach out to y'all and have a scheduling conference on when best time to do sentencing would be. We'll try to get that scheduled for you. All right. But ma'am, you will be remanded into custody after you've been convicted. Your bond is deemed insufficient at this time. You'll be taken into custody, await sentencing. All right. All right. Y'all can take her in the back. If y'all need a chance to talk to her, y'all keep her here for a little bit so that the attorneys can talk to her if they need to. All right, anything else? All right, we'll be in recess. Thank you.
Well, everybody, so there you have it, guilty of all charges. So I thought it would be, like I said, as you guys know, I thought it would be I thought it might be a compromise. That was my opinion. I thought that especially with the length of time this jury was taking, and the fact they were deadlocked, that would be a compromise there. But clearly, this jury obviously got caught up in what everybody else has gotten caught up in the statements of Rusty, and they're looking and they think, I'm sure, like I said, one of the overriding themes I'm sure in that jury room that took over was she's involved in some way. They don't care to what extent, so they're going to find her guilty. But I mean, listen, if you go out and you look at the more than 70% of people that in the polls out there that have said she's guilty, the Rusty tapes, people, look, this jury heard things one time. So, you know, it took all of us a little while in digging into the evidence to really look at this thing correctly. But clearly, this jury believes that guilty is the correct verdict. I disagree with it. Obviously, you all know that. I think there was a reasonable doubt. I think there were several reasonable doubts, and I think I think this jury's going to get out. I think that there's going to be some people in there that will probably regret that verdict and not having dug in. But I think the judge. I think it'll be interesting because to me, I'm a little bit unsure of whether or not the way the judge gave that charge. There's something called the Allen charge, and the Allen charge. When they were in Florida for the Ty Tucker case, that judge was ultra careful with how they give it. A lot of judges are ultra careful in how they give it. This judge wasn't careful about anything. He just decided, this is how I'm going to do it. This is what I'm going to say. And I think on appeal, the appeals court are going to have to consider whether or not the way the judge charged that jury for the Allen charge, whether or not that was something that was constitutional or not. Because to me, I'm not convinced that it was. Just the way he said it, because he made it sound like you need to go back and find a verdict, get a verdict, and you're not leaving until you do. It's like, we're locking you here. I'm here till 5:00. I'll check back in with you. And that's concerning because, now obviously they came to a verdict, but I can only imagine that in that jury room, what it was like if there was one or two people wanting to hold out and the judge basically says, you're not allowed to go home. And I guarantee you it got extremely, extremely adversarial in there because people wanted to leave. And they're like, hey, I want to leave. I need to get back to my life. And this judge has basically said, we are not allowed to go forward until a verdict comes. And I've never heard a judge charge the jury quite like he did. So I think that's ripe for a potential appeal. on that. Now, what I didn't hear though was the defense attorneys make an objection because it seemed like they'd already discussed what was going to be said. So, well, Charlotte Britt, again, what disturbs me is the concern I have with this case is the experts that said that she couldn't have possibly started that burn fire. And that's a major concern. I mean, any way you shake it, any way you look at it, that is a major, major concern of mine when you've got a situation where it's just scientifically not possible that she could have done this. Now, I think the defense didn't make a big enough deal about it. It wasn't one of the sandbag or one of the fertilizer bags that they brought over and stacked up. It should have been the cornerstone of the defense, in my opinion. And everything should have built off of that from that point on. And by the defense essentially agreeing that this happened on the 3rd, it kind of blurred the impact of that because it was something that was brought up and thrown in there by Michael Ray. And he said, I always found it interesting, that the state's expert said, and it was like an aside. So many people didn't even catch it. It clearly didn't. It wasn't caught during the testimony. It wasn't caught when I was on first pass of that expert because I only picked up on it in a closing argument. And then I started looking deeper into it and said, oh my God, like that's massive. And what that does to the entire case, that just destroys the entire case of the state. And yet her attorneys did not make that a focal point. They were focused on believing that the weight of Mr. Farris was somehow the greatest piece of reasonable doubt. And while that is compelling, it's not the greatest piece because they said, hey, she could find a way to get him down there. Or like many people speculated, he goes down to the fire pit and he shoots him. I mean, there was many ways they could have concocted in that jury room that she got him down there. The problem is all of those ways go out the door when the expert says this fire couldn't have started before 1:09 p.m. on the 4th. So these attorneys made a huge mistake in not focusing on that. But I guarantee you, yeah, she's got to be shocked because where she's going ain't going to be fun. So listen, if she was trying to poison Gary, and I believe she probably was based on what the fact that Gary's last message was, I'm about to eat tonight. We'll see how I feel. She's getting that karma coming back at her. But she's going to be going away for a long time, and that judge is going to definitely lock her up, I'm sure, for life. I mean, I don't think you get another sentence other than life without parole in this instance. I mean, she was found guilty by a jury of 12 for putting her husband on a burn pile, shooting him, and then putting him on a burn pile. I mean, it doesn't get much more shocking than that. It doesn't get worse than that. And here we are. So there it is, guys. I mean, listen, I enjoyed covering the case. I'm not necessarily happy with the verdict, but I respect the verdict. And I think she got a fair defense. She got a good defense. I think the attorneys missed the big fact. And I think they missed the biggest piece here that could have helped their client. And they left it as an aside when it should have been one of the biggest pieces of evidence that they talked about. And I don't know why they didn't. Now, this doesn't mean that a good appellate attorney doesn't pick it up on it, doesn't do something with this. But it's bizarre to me that it was not the focal point of their close, that it was not the focal point of their case, that it was not the one thing that they were going to talk about until the cows came home, and that was Dr. Pope's testimony in regards to the fire. And the fact we have a lady on the 4th who says she smells the fire. We have Scott with no alibi for the time that the fire was going to be burned. Now, perhaps maybe the state would have absolutely wrecked that and came in and geofenced him and found out that his phone was up there. But that still doesn't mean he couldn't have left the phone up there and come back down. I mean, this is this is disturbing because if she is innocent, then that's upsetting. But it does not mean she wasn't involved in this. It does not mean that she wasn't involved in this. It means that the jury had a path to finding that, and that would have been the best argument to do so. But there is still the possibility that something went down, that either she or Scott shot him. She could have still been the one that shot him, and then Scott was the one that burned him up. But I think that what they believed is that the way those phone calls occurred on the 3rd, at the end of the day, that's what got her, those phone calls. And of course, then you have Rusty's statement. But again, Rusty's statement is discredited by the fire expert. But the problem is the defense didn't tie that argument in. So, it is what it is. It's a shame. But like I said, it's kind of a mixed day. But we respect the jury's verdict at the end, right? So I'm inclined to believe to some level she was involved in this. I just believe that Scott was too, and I hope that the investigation doesn't end right here, but it probably will, because this jury's returned a verdict against her. So I highly doubt the state of Georgia is going to proceed any further with anything else. Although I really feel that the judge absolutely for certain has his own suspicions. But again, here's the deal. If there is a time that Melody may be willing to tell what actually happened, now is that time. She could be willing to spill the beans if there are beans to be spilled on someone else. And we're going to find that out, because she's looking at the rest of her life in prison to never come out. Well, Marjorie, that is exactly right. This was the idea was to discredit her. It was a campaign to discredit her, make her look bad, and make the jury hate her. And there were members of that jury that hated her. And as I told you, that if a majority of that jury was leaning guilty, they would be able to break that deadlock easier than if you had a majority of people that were feeling not guilty. And the one or two that would be feeling guilty, they would have had to come into some sort of again, that's where we would have gotten a 4 or 5 verdict versus a 1, 2, 3. So, and then of course you got the Martha Jane testimony. Look, what the state did is they simply gave the jury a path to guilty, and that's what they did. And they threw as much mud on the wall as they could, and they got there. Sad day for justice, in the sense that I think that there was absolutely 110% reasonable doubt in this case. And this is a case that did not meet the legal definition of guilty. But as we will see, and as you will see as we continue to cover these cases, especially when you get down in the South, that doesn't matter. There is no presumption of innocence in certain areas. And down there, the presumption of innocence is a difficult thing for a lot of people to apply. And in this case, if it would have been applied, boom. But it is what it is. There's not much we can do, right? Now it's in the hands of the appellate attorney. And again, remember, the process of justice is not over. It's just moving on to the next phase. Because now this trial is going to get reviewed by the appellate attorneys, and they're going to get a chance to pick it apart, and they're going to get a chance to take it and appeal certain things. And this judge's performance is going to get reviewed, and then we're going to get to hear from the appellate court on whether or not they affirm the conviction or they send it back for another trial. It's possible this could be sent back for another trial. Like I said, one of the issues I believe that is, to me, was just stood out to me in this case among the MJ issue is one, but when you're talking about the way this judge charged that jury on the deadlock, I thought was problematic. problematic. Well, what I want to understand, the people that are so convinced of her guilt, why are you glazing over and glossing over the medical or the doctor's testimony, the expert testimony put on by the state that fire was started after she left the property? How does that fit into your story? Because unless you're willing to admit she had help and someone else lit that fire, how does that fit? I don't think the jury was even thinking about that. I think that just went right on by them. And but that's a concerning thing that I'd love to understand if a juror was willing to answer questions. I would love to just know, was that ever discussed or brought up? How did they get past that? Because that's the part that's concerning to me. And once you look at everything from the perspective of the CPAP machine can't be trusted, and you apply the judge's instructions and you apply the analysis that's supposed to be applied in a trial and the presumption of innocence to things like that, and you look at it from a perspective of innocence and not a perspective of guilt, and you look at the CPAP machine and say it can't be trusted. It was an unverified program that was used to look at that data. Therefore, all data, all conclusions can't be used. Out. So now we don't know when he died. And then you have cell phone data coordinates that shows his phone was moving all over the property. Now you say, okay, well, so was hers. Well, if you looked at the phones in my house right now, they'd all be kind of all over the place. So it just shows you were there. It shows your phone was moving, shows your phone was active, which tells me he could have been alive. That's doubt. Then you get into the real nuts and potatoes of it, and that is this. The doctor says this fire could not have started more than 24 hours from the moment they took that temperature, which was after 1 o'clock on the 5th, which means it had to start after 1 o'clock on the 4th, which we now know there's no way Melody was there on the property at that time. And there it is. And I understand everybody wants to look at the phone calls and everybody wants to look at the Rusty call, listen, the Rusty statement, I just cannot believe people can't understand how that was garbage. That is absolutely the most garbage evidence in the entire case, and yet everybody is using that for a conviction. That is crazy. Come with something better than that. And then you go, well, she said she wasn't supposed to be so burned up. Okay, that was weeks after she'd already talked to the police and already talked to her lawyers. And it sounds like that's something she's saying as something she'd been told, not something that, how the hell would she know how burned up they were supposed to be? Like, where was the evidence from the state that showed that she was some expert on burning bodies in a fire, that she would have even known that? So it makes no sense. It makes no sense at all. But you know what? This jury got blinded by the smut in the dirt. And that's what it is. They got blinded. So let's do another poll here. We were at 60-40. Will the jury be able to return a verdict? 40% said no. Interesting. Let's start a poll. Did the jury get it right? Get it right. There we go. Let's see here while we still have some people in here to vote. Vote on your way out if you're leaving. But now we move on to the next case. We've got another case cooking, guys. So I would implore all of you to head over there. This one is going to be just as dicey as this one in terms of the circumstances. I think guilt is definitely. I don't think it'll be as in question. This is a gentleman who says he was present at the death of his girlfriend, but he says he wasn't responsible for it. That he did not actually cause the death of the girl, of the woman. That he was present. It's a pretty crazy case. It's actually one that went to trial really fast. That happened in February of this year. We're in November, so we literally had had a 9-month turnaround for this to go to trial. And I really don't expect that this is going to probably be much of a debate when it gets to the jury's verdict. But it's interesting nonetheless. And it's a good kind of this one is one where she disappeared and was dumped in a lake, not in a fire. So some definite, a little bit of a different perspective there. So it will redirect you when we end this stream over there. So check it out, pick it up. Testimony's going on. Opening statements happened. I have those already up. So get caught up on this trial because this one's interesting. This will be the one we'll be watching the rest of the week. So check it out. Hopefully I see everybody over there once we get done with reacting and doing this. And listen, we're going to talk about this case a little bit more. We're going to continue. Yeah, it's the pond. That's it. Yeah, I said lake. It's the pond. Yeah, correct. It's the body dumped in a pond. Yep. So it's well, now, Mary, listen, I don't think the jury was mentally challenged. Listen, we don't want to attack the jury on this, right? The jury, remember, the jury gets one pass on this stuff, right? And what I mean by that is they don't get to go back. So I can tell you, when I was first watching all of this, until I was intrigued by the defense's closing to go back and re-listen to testimony that I had missed, I again, you've seen the evolution of where my thoughts went. At first, I'm like, she's guilty. Then she's on the edge, and then well, it could have happened. And then I realized it couldn't have even happened on the third. And then as I start to get my hands around all of this, and I go back and re-listen to stuff, they didn't have the ability to do that. They didn't even have the ability to get a read back. Okay, so this is a difficult case on the jury for the jury to process, especially with it being 20 days. There was 20, well, I guess there was 17, 14, 15 days. I guess it was a testimony. I mean, there was a lot of testimony that was going on in this case, and there was a lot. And again, the state puts the MJ stuff on at the end, right? And Elizabeth Hunton, if you watch from day one, I respect your opinion, but I'd like you to please be the spokesperson for the guilty people. And can you please explain to me then what your theory of guilt is when you learn that by the state's own expert, that fire couldn't have been started until after 1 o'clock on the 4th. So who started the fire, and how did Melody start the fire from Lake Lanier? And then how does all of that tie in? Where does all of that go? How do you establish now when you say the CPAP is no longer credible? It was used with unsourced, unsubstantiated computer program. So how do you make this make sense? And if there's no fire on the third, and if there's a neighbor who's a medical examiner, who's a witness against her in this case, telling us that she smelled the fire on the evening of the 4th. And then you've got Scott with no alibi during that time on the 4th. Where? Just help me to see the theory, because you have to deal with that. Nobody wants to deal with that. Everybody reverts to Rusty and this and that. So I would like to understand that from the guilty people. How does that factor in? And then when you look at the Rusty statement, I want to make sure all the guilty people understand that was not a recorded statement. No one heard that. And it was Rusty telling the police, faced with an arrest warrant that was fake, when he came up with that statement, which then turned out to be uncorroborated with any evidence known at all. And then not only that, but to further destroy that statement that Rusty made, which proves it was false, there was not even a burn pile possible to be going on at that time. Certainly not one with a body on it. So please help me. If you're watching this in a replay, put it in the comments. Lisa Sharp, I just explained why Rusty would lie. He wasn't, and he explained why he would lie. Okay? He explained that. Like, I guess it's hard for people to understand when you're sitting there with the police. I mean, are you not aware of the statistics on false confessions to police when they use these tactics on people? when they use the read technique, when they present people with false warrants and they lie to them, people will say things to the police that in situations like that, just simply because they're freaking out. And that's what happened with him. Please point out the corroboration for Rusty's statement, especially when we find out that the fire that he says was burning with the body on it wasn't even able to have been burning until after 1 o'clock on the 4th. No one will address that. Lisa Sharp says eating watermelon candy. He wasn't scared. What do you mean eating watermelon candy? He was scared to death when he saw an arrest warrant coming. They told him they had an arrest warrant. Even his attorney said that he wasn't expecting what Rusty was about to say because it was out of nowhere. Well, again, even if it was started before, the expert said that the fire, based on the temperature of the coals, couldn't have been started more than 24 hours before they took the temperature of the coals and the body. What is it that people don't understand about that? I don't understand how that's not clear when you go back and watch that expert's testimony. That is a state expert. That's not defense. That was paid for by the state of Georgia. So, if that fire was started, and that's even worse for the state, because if that fire was started and it was roaring, and that's when his body goes on it, and people are going to suggest that he was shot into the fire, okay, that's problematic, because if that fire could not have, that is the point that no one is understanding in this instance, or seems to be flying over everyone's head. That fire couldn't have been started until after 1 o'clock on the 4th. Nick, sir, okay, what do you mean that means that was started? It was not started. It couldn't have been started on the 3rd, Nick, sir. What that means is that the fire, okay, that when his body went on the fire that burned there, okay, that was the fire that was the one burn through, could have only been started after 1 o'clock on the 4th when she wasn't there. This is the problem. This is evidence that was presented in the case. It's and that's just concerning to me, that it's like everyone is so quick to come up with all these things, but they will not. No one in the guilty camp will address that. And again, the defense never held it. It did not make a big enough deal about it. Marianne Crocker, why would Rusty say don't tell me anymore? Because he made that up. Mary Ellen, you did not hear him say any of that. You did not hear him say that statement on a recording. He told the police that because he was trying to minimize, and again, even the police disagreed with that and said that doesn't make any sense that you would even say that in response to what she was telling him. The police, I mean, you're listening to the police. I hope you listen to the whole statements. We're cherry picking here. But the police that were listening to Rusty tell that story did not believe that Rusty actually said that to her in response to her telling him he was on the burn pile. When Rusty said, that's what I said because I didn't want to know anymore. And they said, there's no way. You're telling me someone tells you there's a body on a burn pile and you tell them you don't want to know anymore and never ask another question. So the point is that is not irrelevant. Like, that has no bearing. And listen, I can see that jury for some reason not understanding this stuff. That's what was, I'm sure, being said back there. But, that's the problem. Well, he might have known more. Maybe he did. But the point is that statement is not credible. And if you're saying that statement, people are acting as if that statement is actually credible or as if it was recorded or something. It's not. It wasn't recorded because that was never said. And that conversation was never had that way. Anything that was talked, no one knows what was talked about on those 3 hours of conversations over that 3 hour period. It's very likely that that Gary could have been killed during that time. And she could have been talking about it. But there wasn't a burn pile going on at that time. Because what you have to realize is Gary had already told Chris that night that he was burning the burn pile the next day. Okay. So they would have not started things if Scott and his mother would have been trying to make this look like it was Gary who was going to fall in, which is most likely what whoever did this was trying to make it look like. They weren't going to start the burn pile at a time Gary wouldn't have possibly started the burn pile. That doesn't even make any sense. Okay. So if he got shot or whatever happened, okay, it would have been then. My opinion is something happened to Gary. He got upset. Whatever. There was some sort of confrontation with Gary that occurred on the night of the 3rd, and he passed away. Whether it was whatever. We don't even know for certain that the gunshots what killed him because we know it was superficial gunshot wounds. So it's possible the gunshots could have been done to manufacture it. It could have been done by Scott later on when he decides, you know what? I'm going to go for it all. I'm going to set my mom up, so I'll shoot him, put him in the burn pile, and then go set her up and put the bullet inside. Because remember, he's the last person inside before that bullet's found. The grandchildren are down there. They don't find a bullet. They're all down through that basement. But the thing is, we'll never know. We're never going to know unless Melody is willing to speak. Now, it's interesting that she didn't take the stand and say it wasn't me. It's interesting that she didn't do that, which makes me believe that she was involved in some degree of knowledge to this and what was happening. And, that's problematic for her. But look, the problem that I have here is that the standard to find someone guilty in a court of law is proof beyond a reasonable doubt. And there is no way in the world that the state's case met that standard in this case with as many questions. And as you hear all the different scenarios and all the different things that are flying around out here. And I guarantee you in that jury room, they didn't even realize it, but I'm sure every single one of them was demonstrating that this case was riddled with reasonable doubt. They found a way to find her guilty because they hated her. And you had a judge who let this thing be a free-for-all. And that's kind of how these things can happen. Well, Nick, sir, it's a clue that he was shot. There's no question he was shot. The question is, did he get killed by being shot? That's the point. You don't know and can say what happened. That's my point. My point is, and again, it's something that seems to be lost on everyone. When you're in a trial, you're not allowed to speculate on anything beyond what it says. And what we heard from the medical experts, which everyone seems to want to disregard with their own speculation and hypothesis, the medical experts said that the bullet in the rib didn't enter. It did not break bones. It did not enter the body cavity. It was superficial, meaning it would not have killed him. So what we don't know is, obviously, could there have been other ones? Possibly, but we don't have a gun that shows how many times he was shot. We know there were 2 bullets, one inside that had skin DNA on it, but that does not mean he was shot or where he was shot. And we have no blood around it, no indication that there was big blood puddles or smears or anything like that. It's in a strange spot in between a chair and a couch. Okay? There's no blood on the chair. There's no blood on the couch. There's no blood on the wall. I mean, the fact that this doesn't bother people is concerning. The fact that the jury just flew over the jury's head is concerning. So then you have, okay, everybody's theory was, well, she chased him out to the burn pile and shot him and he fell on the burn pile. Okay, maybe she did that. But that burn pile couldn't have been started until after 1 o'clock, after she was already gone. So who helped her? If that's what happened. But my thing is, something obviously happened because he's dead. And my thought is that there's something that happened on maybe the night of the 3rd, maybe it was later on the 4th, but we don't know. And that's the problem with this case is how can people be comfortable putting someone in prison for the rest of their life when it's just not known if she actually did this or not. This is exactly what the protections of our justice system, this is the type of case that it was built for. And the problem is when you get prosecutors who are able to present evidence like MJ's evidence, that should have never come in. And that's going to be a big issue because you take that out, then you have it's a whole different story when you remove MJ's testimony, I believe. And there's a whole different field on that jury. Listen, if he would have been shot in the house, he could have run into his office and grabbed his phone and called 911. Okay, and given the fact that we know it was a potential superficial wound, Gary was confronted. Whatever happened, I believe, in the barn, and I believe he was out in that area whenever whatever happened, and then whatever happened out there. And we don't know. And I believe there was a separation between what happened and then him going on that burn pile. I don't believe it was all in one time. And I believe Scott left and went and played golf. I believe he went up to the lake. And I believe that definitely she had to have had help getting him to the burn pile. And I believe this jury basically looked at it and said, look, we believe she was involved. And even if we believe she was involved and Scott was involved, it doesn't change the fact we believe she was involved. I think the struggle was trying to figure out where the charges fit for that. And I think that they just decided, you know what, that might have been where they were deadlocked on certain charges and stuff. And then they came in and they just said, you know what, listen, Juror 1, do you think she was involved? Juror 2, do you think she was involved? All right, we know she was involved. Convict her of everything. At that point, it's done. We think she was involved. We don't know how she was involved. We don't know specifically how it went down, but we think she did it all. And they just said, we want to get the hell out of here. And then when the judge basically said, we're locking the door and keeping you in, and you will not be allowed to leave until a verdict comes down, I think that was enough for everyone to say, you know what, listen, find her guilty. Like, there's definitely not a route in their minds that they believe because they were not walked down the path. Because I don't think any of those jurors probably missed, like many people did, the expert testimony of Dr. Pope, and it was brought in. And if you say, well, the defense brought it up in their closing, they did, but a lot of people missed it. And then it was not brought up at the end of the closing. It was brought up at the beginning, in the middle of the beginning. Cam Winslow, I disagree with you. So explain to me then who lit the fire then on the afternoon of the 4th. Who lit the fire? Who's the one person with no one accounting for his whereabouts on the afternoon of the 4th? You tell me, Cam. He had to be involved at some level for this to go down. Cam, you again are not addressing the issue that is present, that the fire could not have been lit when she was here. And therefore, if the fire was lit and it was lit by Gary, that's even worse because that means she might not be involved at all. That means he might have actually been alive. So you can't have it that way. That's not where you really want to leave it at. So Lori, we'll pull this back up here. So Lori Nichols says she watched every minute of. She is so guilty, so much proof. She's mean enough to do it. Justice was served. God bless our judicial system. She said he's in the burn pile the night it happened. Okay, Lori, where is the so much evidence? Okay, and again, if you would be so kind, there was no burn pile on the 3rd. That's impossible. It's scientifically impossible. So if there was no burn pile on the night it happened, it didn't happen at night. That was the third. And allegedly when she's saying that, it's 12 hours before that fire could have been lit. So please explain to me how she is saying that statement when there is no burn pile at that point. There's a burn pile he's planning to burn, but there's no burn pile lit at that time. And who lit it then? Who lit it? Who burned him? Why did Scott claim to see the burn pile lit when he got home? Does everyone forget that? If there was no possibility of a burn pile being lit, that was in there. Go back and watch the questioning of Scott. Go back and watch when the defense attorney says, we have a witness in this case who says he saw a burn pile burning. He said, well, it could have been another burn pile, but this particular burn pile with the one with the body in it, that's the one that was burning through where his body was burned and then one passed fire. That one started after 1 o'clock. So how is it possible Well, I know Karen Williams. I thought, and he's kind of a dangerous type judge because, he's the type that, like, I'm sure made Melody feel a little bit more safer than what she probably thought she should have. There was laughs and smiles and jokes. And then, of course, as soon as it's done, he's locking her up, and saying, all right, revoke her bond and send her away. Of course, he had no real ability to not do that. Okay, Lisa Sharp. He's in the burn pile. She did not say those things on the same. First of all, she did not say those on the same. She did not say those on the same conversation. And he's on the burn pile was never recorded ever. She was never recorded saying that. That was a statement that Rusty said. And what she's saying to Rusty is if you keep talking like you're talking, then you're going to hang me and I didn't do anything. You're forgetting the part right after that. She said, I didn't do anything. So you got to put the whole statement in. And there's nothing wrong with her having said that. That's not a suspicious statement. To me, that's a statement that says, like, I'm innocent of this. And if you keep talking and saying the shit you're saying, I'm going to get convicted for something I didn't do. Okay, Laura Nichols. She lit it and fueled it with citronella. Odor was reported by detectives. Gunshots heard by neighbors. Okay, there was a neighbor who did hear a gunshot, which would mean that that's when the gunshot happened. But the fire was smelt by neighbors on the 4th, not the 3rd. You understand that neighbor also did not say he smelled a fire burning that night. He didn't. No one smelled any fires burning on the 3rd that was reported to anyone. They did not have a recording of her saying he's in the burn pile. No, they did not. That is not true. That is 100% not true. Send me the link. Laurie Nichols. They did not have that. They had no recording. They had a recording of Rusty saying, didn't you tell me he was on the burn pile? And she actually says, no, I don't believe I said that to you. She said, I don't believe I said it to you then. And when the way he was saying it to her is it was being said not in the night of when he tried to specifically get her to say that, she said, no, I don't believe I said that. I believe all I said is we were talking about this and that and the other. So there is no recording of her anywhere saying he's on the burn pile. Never. That never happened. That was never recorded. That was a statement that Rusty said he heard her say on the 3rd. It was never heard. All right, if you heard it, by all means, please find a testimony and link it and put it in where you heard her. All you ever heard her say was you heard her be asked the question on a phone conversation. Did you say that? Do you remember when you said that? And she says, mm-hmm. And then she says, huh. Well, I remember, I was told he wasn't supposed to be burned like that. And then he said, no, baby, no, remember when you said that night? She said, no, I don't believe I said that. We were talking about da-da-da-da. And she doesn't even know what the hell he's talking about. She doesn't have a calendar out in front of her. This is weeks after. There is not a recording of her calling him saying, Gary's on the burn pile. He did not record that conversation. That is not a recorded conversation. That has not ever been heard. And this is that. So go find it. You will not find it. In fact, I have every single one of those statements. You can go right here, easily find it right here. Every single one of those statements is documented on the channel. So you can go right on through. As they were coming out, I was recording them. Go find it. You will not find it. It's not there. There was never the conversation on the 3rd was not a recorded conversation. That was a conversation that was reported to the police by Rusty. End of story. That is incorrect. Cam says she shot him inside. He stumbled outside. She could have lit it. Cam, it couldn't. Again, you're failing to address the issue of the fact that the burn pile could not have been lit that night. It scientifically could not have been. It was lit sometime after 1 o'clock on the 4th. She was not, and that's PM on the 4th. And she was not on property at that time. Well, now, Turner, you can't see Turner. You cannot hold that against her, and the jury can't hold that against her. Now, obviously, the court of public opinion can, but in a court of law, that can't be held against her. You have the right to remain silent. Again, this is the problem what we have with struggling with the idea that someone is presumed innocent when they go into court, that they don't have to speak, they don't have to answer questions. No, Brookie, that's not true at all. That's not true at all. And when defendants testify, they take away from the burden of the state, because then everything turns into the burden of her and her testimony and whether or not it's believed. And this was a case that the state's burden should have been what the jury was concerned with. Oh, and no question, Deb, I agree with that. The jury spoke, and I respect the jury's verdict. I just think that the jury probably, based on the size of this case and the fact that I think the defense focused on the wrong major points of reasonable doubt in this case, and the net result of that was when that jury went back to that jury room, again, they're right where everyone else is, that no one is worried about the scientific proof that the fire couldn't have been lit on the 3rd. And then when all of that leaves, and then you're left with, what is the proof she did this? And then you have that, unfortunately, it's a really uncomfortable feeling, because now you have all this hate that you feel for her. You have all this stuff that she said on recordings, and you're like, damn, I really want to convict her. And then that's where it goes back to say, well, I'm not going to quit her because I think she's a bad person. I think she probably did this. I mean, they had it all in there, man. They put the kitchen sink in on her. Poisoning, even though he was put on a burn pile. I mean, you heard all of it. This jury hated her, and it took them a while because the case was so weak. Tam, first of all, she couldn't have asked him to light it because Scott wasn't back on the property to do this until after Melody left for Lake Lanier. Because, again, I repeat, the science says the fire couldn't have been started till after 1. So if Scott came back, which my belief is he would have been the only one available, that would make sense to have the one to come back. He's the guy telling everybody on the 911 calls that he's experienced with burn piles and burning bodies. That if he comes back at 1 o'clock to start this fire and get this done, she's not asking him to do that. He's coming back knowing there's a body on the burn pile. Boom. Well, Judy Davis, that's the point. There's a lot of doubt in this case. So I think that if the hate level wasn't so high for Melody, this is a type of case that screams for a not guilty, not because you're declaring her innocent, but you're declaring the fact that the state failed to meet their burden. And that's what should have been done here. But listen, I understand why it wasn't, because the hate level for her is so high and so overwhelming that they just weren't. They just weren't. Listen, again, the people that are coming in and saying the jury got it right, I respect your opinion, but what I'd really like you to do for me, no one has been able to do it, is explain how the jury gets it right if the fire couldn't have been started till after 1 o'clock on the 4th. That is a damning piece. That is a damning piece of evidence for the state that no one. Well, I'd be emotional too if I got away with something like that, because he knows that her being found guilty secures his ability to get away with all of this. Debs, the reason why again, in this case, money, okay, or again, I don't think, I think the thing that if Scott was responsible, I don't think Scott was like, I'm planning to kill my dad today. I think it was a situation where something happened between them where anger got involved and something just happened. And when it happened, he was left with an outcome. And when that outcome occurred, boom. So that's what I, that's what I am inclined to believe here. Okay, Cam, if he lit the fire with his father on it, which he would have had to have done, that is absolutely intentional. Well, now under your scars, they deliberated a little bit longer than that. They deliberated for 2 hours on Wednesday. They deliberated a full day on Thursday, or they left at 4, so it was almost a full day on Thursday. They deliberated a full day on Friday. Okay, so they deliberated about 17 hours in the first 3 days, and then today they deliberated another, I guess it was another 4 hours. So they were at about 20 plus hours when they went to the judge and said, we're deadlocked. And then the judge basically said, I don't care, go back in that room and find a verdict, or you're not leaving until you do. And then here we have it. And I wasn't surprised that, the only thing I was surprised about is I thought they might compromise. I thought there might have been a compromise verdict. That was what my thought was. But it's it's a tough case. It really is. But it's a fun case to watch. But at the same point, I use that word lightly because, or carefully, because, when you're saying something like that's fun to watch, it's a tragedy for a family. So, at the end of the day, a man lost his life. And so there's nothing fun about that. And that's very, very sad. Very, very sad. So that shouldn't be taken lightly by anyone, but it's extremely sad. At the end of the day, this family lost a father, right? And the one I feel really particularly bad for at the end of the day is Amanda Farris. I really feel for her, because I think out of all the kids, she's the one who really loved her parents and was really there for her parents, both of them, her father and her mother. And the rest of the kids all had a tumultuous relationship. You had one stealing from them. You had the other daughter. I think the daughters were okay. But the one daughter, of course, they were involved financially. The other three were involved financially with the parents. So, how am I exaggerating what the judge said? I'm saying the judge did not read the Allen charge as the Allen charge is read in most cases, which comes directly out of the case law for Allen, for an Allen charge. He gave his own version, but the concern I have is he did not read the Allen charge to the jury the way it's supposed to be read, which is normally when you give the Allen charge to the jury, it's basically, listen, we've been at this, and again, I don't have the exact verbiage, but it's basically where you say, listen, go back and discuss and hear everybody out and hear everyone's concerns, and then come back and if you're not able to come to a verdict, let us know, and we'll go from there. and once the Allen charge is read, okay, then there is no more. He never gave the Allen charge, I don't believe, and I don't think that would count as the Allen charge. If it does, it's again, that's an issue all in of itself. But the Allen charge was never given in this case, and the jury said they were deadlocked. Now the judge made that decide. You know what? I was waiting to give the Allen charge because that would come next. This time I'm going to tell them to go back. But he told them basically, in so many words, don't come back out here until you have a verdict. You're not leaving. Like you're not leaving. And 16 hours, I think, is not the correct calculation on the time they've been deliberating, because 16 hours is what they deliberated from Wednesday to Friday. And then they had deliberated, it was around lunchtime, so they deliberated another 4 hours, almost about 4 hours. So they were at 20 plus hours at that point. And then 2 hours later, they come back and they got a verdict. So, you know. Well, that's what I'm concerned with. He did not give the Allen charge. Now, he may feel that there's some leeway with that he's allowed to tell them. But again, I don't believe what he gave was correct. Again, you can bet your bottom dollar she'll be having some appellate attorneys review this case. But I can tell you that is a big concern. And Tammy Sheets, listen, I guess you're not understanding what I'm saying. So I understand if you're not able to comprehend high-level legal concepts. So, you know, if you're failing to understand the importance it is when you have a jury who goes back and is given the perception that they're not going to be allowed to leave, and the impact that can have, because the judge is not supposed to influence a juror's verdict, and you never want a juror to come up with a guilty verdict. Okay, to come up with a guilty verdict solely to go home. That is absolutely an extremely concerning situation when it comes to justice. And that, if that happened in this case, again, you just wasted 21 days of trial, all because this judge decided not to follow the law because he was afraid that it would end up being a mistrial. But if that's where it needed to be at, then the state needed to get another opportunity to try the case, and the defense would get another opportunity to defend the case, which they might get. Because, again, I think that's going to be one of the biggest things that could stand out here in the record of the case, besides also the issue of allowing MJ to testify at all. So it'll be interesting. I think we will. I think Court TV, I'm sure, if there's a juror willing to talk, and I'm sure there will be, we'll get to hear what goes on there. Well, that's Marjorie. That's the Allen charge is supposed to prevent that. Okay. But it's also supposed to encourage them to, but it's supposed to encourage them to go back and have a fruitful discussion with their fellow jurors. But, you know, look, this judge was kind of an unorthodox judge. He was a laid back guy. He had his own way of doing stuff. You know, I thought he was entertaining, but you know, so, but at the end of the day, listen, we have to respect the jury's verdict. We might not agree with it. Like I said, all of those concerns that I'm talking about would be something that will be taken up on appeal at a later time, and they will be. In the meantime, she's going to spend some time in jail. I think you could tell. I think it was like a slow process of her dealing with the reality that she'd just been convicted. I mean, I can't even imagine the weight of that at that moment when you're realizing, as she had walked in that courtroom like she had every day for 20 something days, for 21 days. She'd walked in and out of that courtroom with everybody else, I'm sure, in the midst of all sorts of feelings. and then everyone else is going home, and she's going to jail to go begin hell on earth, because that's where she's going, and it ain't going to be fun. It is not going to be fun. And I can't imagine, I'm sure she can't even imagine what it's like. Yeah, that is true too. They did not show her any comfort. They did not. You're right on that. That was very strange. That was extremely strange. I agree with that. It was extremely strange. Um, um, but maybe they know more than what we know. Remember, there were polygraph tests taken in this case. And again, that's something else that's kind of glossed over. I mean, Scott took a polygraph test and failed it. I mean, that's, well, I appreciate it, Lake Bloomer. Like I said, listen, um, that the point of what I'm trying to do is just help people to understand how to view these cases from a perspective of the courtroom, and what's supposed to happen here. So I'm trying to give the, the and it's different. It's different than the way we're going to look at it out here, because, well, listen, Cam, now I believe there's something more to that, right? If you want to talk conspiracies here, she got something going on with her teeth, okay? And again, there's nothing more than that. There's a reason why she's doing this, because she did not want to show off whatever's going on with her choppers. Nobody knows what that is. And that's something that I hope, if her defense attorneys sit down with court TV, somebody's got to ask that question, because there was something going on, whether it's bad dentures or maybe she had no dentures, whatever, but something was going on with her mouth. And that's why she sat there like this and didn't want to show emotion and start crying, because she just wanted to cover her mouth up. Now, whatever that is, I have no idea, but I'm sure she is feeling very, very shocked right now, and I'm sure it's going to be not a fun week for her. Not a fun rest of the year. But I think that was weird. Whatever was going on with her teeth, because she did everything she could to cover those up throughout the trial. But I don't know. I don't know. So rest of the week, it looks like, I don't know if you guys saw also, Adam Coy was convicted as well today. He was convicted. Kind of spoiled it, but the verdict's up. You got to go watch that verdict. That was interesting. And his team was trying to keep him out on bond, because he's in the middle of a bone marrow transplant, taking 80 different pills. And the judge basically said, I don't care, lock him up. Tammy Sheets, what experience do I have to lead people through trials and jury? Well, it's interesting. I guess you're not a long-time follower of the channel, so I guess you don't know the backstory. So my dad, basically, I've been around the criminal justice system since I was a little baby. My dad was a very well-renowned criminal defense attorney out of West Virginia, right outside the Washington, D.C. area. I worked at his law offices coming up. I almost was going to become an attorney myself, and for various different reasons that came in, I went a different direction, went into the financial world. But I've been around the criminal justice system my entire life, and my dad was one of the greatest legal minds you've never heard of, and you're going to hear about it. Stuff's being done about that. But he passed away. He and I started this channel together. And he would have been, in a case like this, you'd have been hearing from him as well, as we would have been talking like we've done, watching legal cases together for years, and also being involved in his cases. And I've been involved with him as his paralegal throughout different legal fights that he's had. Huge history with the criminal justice system. So I have a ton of experience with all of this, and being around this, and being part of trial teams, and being part of trial strategy teams. So that's where, as a trial watcher, I have, learned. Very true, Peggy. You're correct on that. But what I'm saying is that's where I have my experience and have gained my knowledge from. That's where I'm able to share a different perspective, because again, everyone is, again, qualified to be a juror because by our citizenship, but we all bring different life experiences and perspectives. Yeah. So, that's where the experience comes in. So, anyways, you know, from that perspective, but I appreciate that. Brookie, listen, I understand. We're all, in a case like this is a case where this is why, again, it's in the fact that there's as much disagreement in this case with so many people that watch it. That's the definition of reasonable doubt, in the fact that we were not able to say what happened in this case, and still can't right now, and certainly can't say beyond a reasonable doubt, to me, what exactly occurred here. And that is that's a concern. And to me, this is a case that I think a mistrial would have been better served here, because it would have given the state a chance to go back and maybe do some investigating in some areas that came out in the trial. One of them being, I believe there is definitely more cell phone data analysis that could have been done in this, that would have been helpful. That would have potentially answered some of these questions that we have, and they could have presented maybe a much better and tighter case to the jury that maybe wouldn't have so much doubt when it got to them. Well, Nixer, you do have to be certain about something as important as when the fire started, that you're saying burn up a body. Okay. And since you don't know, since the body got burned up and the only gunshot wound that they had any ability to know about was superficial, and then you find out that the body couldn't have been burned up by the expert, that the body couldn't have been burned up before 1 p.m. on the 4th, or after, it was a little after 1 p.m. on the 4th. That's a big problem. That is an element of the crime, Nixer. How do you feel that's not an element of the crime? I mean, one of the biggest pieces of evidence was the allegation that he was already on that burn pile, because she told someone he was already on the burn pile on the night of the 3rd. But if that's not possible, that he was already on the burn pile when that statement was made, it discredits that entire statement. And since the only evidence that they have really that links her to this case, that was the net result, that was the result and the reason she was charged, is that statement. That's huge. And then, like Marjorie just pointed out, Scott, when you start looking at all of the different things here, who has 38 caliber bullets in their room? Scott. Okay. Who has a pristine bathroom? Scott. Who's talking about 38 bullets first? Scott. Who's telling everyone he was shot first before anyone could have possibly known? And no one cares about that. Scott. Okay. Who's the one telling everybody about he's an expert on burn piles? Scott. Who's the one that 13 minutes after the police arrive, he's throwing a shade at his mom and saying that there's a gun that no one's ever seen before down in the basement? Scott. Who's got a missing .357 Magnum that shoots 38 bullets? Scott. I mean, come on. Jesus. It's like, but again, the hate for her was so strong in the room and so strong in this courtroom, which is why there is one of the appealable issues that I think will be present in this case that will have to be sorted out, is whether or not some of that information that came in, whether or not its probative value outweighed its, the damage it did to her reputation. Because to me, it did a lot of damage to her. And sometimes that's one of the weights, is to say, well, bringing some of that in, bringing in all the information about the affairs and all of that, well, I guess it goes to motive. But if it colors the jury to a point that they hate her to a degree that they can't get past that, it was not supposed to be being brought in for necessarily proof of her guilt. It was being proof of her motivations. But if it's so egregious and so outrageous that it ends up causing people to think she's guilty because of it, then that could be a problem that can be explored. Peggy Thursby, what are you talking about? Go back and watch my video, okay? And I have it nicely clipped out for you. She said that was the night of the 4th. Like, this is the thing. If you're going to sit here and you're going to use evidence, at least know what you're talking about, you know? Tammy Sheets, what are you talking about? When did I do that? You excused her telling Rusty he was on the burn pile, then turn around and say she said he was on the burn pile. I never said that. I never turned around and said that. I have been clear that the statement that she said that, I have never said that she said that, because that was never ever played for the jury and never ever played for me. What I have said clearly is that the statement that he was on the burn pile was not a recorded statement, that it came only from Rusty, and that it came only from Rusty when he was under duress. Okay? So, listen, this is what is absolutely so disturbing, is I'm sure there are jurors like what we're hearing here who have watched this trial, who claim they've watched the entire trial, and apparently have also watched other videos, okay? And yet these details just don't sink in. There was no tape of her ever saying he's on the burn pile. The only tape you heard was Rusty asking her, do you remember saying that? And she says the statement about he wasn't supposed to be burned so much. And then she says, no, I don't think I said it that. I don't remember. No, it wasn't that. We were talking about other stuff, the grandkids and this and that. I remember, There is no statement anywhere. And you find it, link it to one of my videos. Put the link in the comments on a video. You find that where she's saying that statement. And Peggy Thursby, what are you talking about? You're sitting here speaking wrong information. Go back and watch the coroner's video. You just say, and the good news is you put it in the comment. You put it here in the chat. You just said the coroner said that the fire was burning on the 3rd. That is not what she said. Go back and watch the video. Go back and watch the video. Okay? That is an incorrect statement made by you. You are stating incorrect information. So, you're not under my skin. I'm just telling you you're wrong. And I'm just saying that it's very concerning to me how people are so convinced of something and they have wrong information. They heard it wrong. And then once you hear it right, this is the problem, and probably one of the problems with a case of this size. There are probably jurors back there who got this stuff wrong, who were confused by it. But the jury did not get the ability and did not have the ability in this case to have readbacks of testimony or to have any of those things corrected for themselves. So they were left with whatever their memory was at that moment that they heard. How was she leading Rusty? Rusty was leading her. Rusty was asking her leading questions, Tammy Sheets. So I don't know how you would even take that conversation that I was talking about there as her leading him. He was leading her. He was asking her leading questions. I would just encourage you, everyone who has these details wrong, go back and rewatch some of these things and verify it for yourself. Go back and rewatch that expert and take some notes, write out the timeline, and it'll become clear for you. I promise it will. I promise it will. And people I feel bad for are the jurors, because they're going to come across some of this information, and then there's going to be people back there that are going to go, man, I should have stuck it out. Man, I made a mistake. And those will be the ones that'll feel bad. Those will be the ones that'll be haunted by this, because they're going to be like, wow, we made a mistake. And there's nothing you can do there. Nothing you can do. So with that said, guys, I'm coming up on 8 hours. That's when my broadcasting has to end. So we've got about 13 minutes left. So this is a good time to wrap it up. I appreciate everyone watching with me. There will obviously now be a sentencing hearing, so we'll all come back together. I'll be certainly covering that, but I don't think I really don't think there will be much to discuss when it comes to her sentencing. I think she's going to get life without parole. I think that's going to be just that. So, but I appreciate everyone who watched, everyone who interacted, whether you agreed with me or not. Listen. I want people in here to disagree. That is what makes it fun, and makes and helps us think and helps us discover things and helps us do things. So we got another trial going on over here. Come over, check it out. We're probably going to find more agreement in that trial than we are disagreement, because from what I've been watching today, I think it's pretty clear that this is going to be a pretty cut and dry case. And no problem. I appreciate everybody there that rode with me here on this trial, and the 65 of you that are still in there right now talking with me. But like I said, we're going to call this one. That trial, I'm not sure what's going on. I'm kind of observing it. It's on break again. It's 4 o'clock. I don't know if it's break for the day or if they'll come back. I know they only had 2 more witnesses, and by my count, I saw those 2 witnesses testify. So I think trial might be done, but you can go back and get caught up on that. I've got a few more witnesses that'll be. You can either catch up by watching it all in its entirety, or I always put up all the different witness testimonies in each individualized testimonies for you to be able to watch at your leisure and break it up into smaller videos. So that way you're not feeling overwhelmed to watch it all in one setting. So under your scars, I am still waiting to I am still waiting to hear things. Peggy, awesome. I hope to see you there. And I think, like I said, I think we may find some more agreement over there. But I'm waiting to get a few things confirmed. And then, like I said, this is going to be huge. So I've got big news, big news on that front. So with that said, guys, thanks for watching. I'll see you over there tomorrow. That's where we're going to be. And then we're going to be talking. Like I said, there is a big special coming up on the Ty Tucker case. Y'all going to be very surprised what's going on with that. So, but it's good. And Cindy Braddock, thank you for watching. Thank you, Peggy Thursby, for coming in and disagreeing with me. Get me fired up. I appreciate everybody that watched, everybody that shared an opinion. Keep sharing them. Even if you disagree with me, let me know. Okay. I enjoy it. I'm going to come out and I'm going to talk about it, and we're going to have a conversation. And you know what? You might just change my mind. You never know, because I am absolutely open to having my mind changed at any time. So with that said, guys, let justice prevail, and I will talk to you soon.